Good afternoon. My name is Caroline Westover. I'm a partner in the Bonds, Labor, and Employment Group, and I also am co-chair of the firm's Immigration Group. So I thank everybody for joining us this afternoon to discuss documenting and verifying employment eligibility with a specific focus on the restaurant industry. Just a couple points before we get started. Certainly understand, and in my experience, clients don't get terribly excited about I-9 issues until they need to. In other words, until ICE comes knocking at their door, that's when most clients pick up the phone or start paying attention to these issues. So just by participating today, you're steps ahead of many employers, and our goal and hope this afternoon is that you get several tips and practical pieces of information to take back with you and share in your workplace moving forward. With that said, we'll get started. First of all, I-9 issues, employment verification issues, are primarily controlled by the Immigration Reform and Control Act of 1986, also known as IRCA. Basically, IRCA requires employers to comply with a number of various components, and there are also a number of prohibitions. Specifically, employers are prohibited against knowingly hiring or employing workers who are not authorized to work in the United States. Now, the standard of knowing is specific. It actually includes actual or constructive knowledge that somebody is not authorized to work in the United States. Constructive knowledge, more specifically, is defined as knowledge that can be fairly inferred through notice, certain facts, circumstances that would lead you to reasonably conclude that something may not be true. So in other words, if you happen to see and witness and observe an employee in your workforce telling others that he or she is illegal and has provided the company with fake documentation, that's good and sufficient knowledge to hit that knowing requirement. If you hear through the grapevine, on the other hand, that there may be an employee who's not authorized to work, simply hearing a rumor may not be sufficient, but again, the burden would be on you, the employer, to do a little more due diligence in order to assess whether or not you have enough constructive knowledge. What we can't do is simply put our heads in the sand and hope that we don't actually get firm constructive knowledge. So the other, IRCA also prohibits employers from continuing to employ workers who are not authorized to work in the U.S. So this is a flexible, ongoing, continuous process. Employers have obligations at the front end when an applicant or new hire comes in the door, but in some cases, your employee may have a limited period of time in which they can work. So once that time period expires, again, employers are reminded to go back to that employee and say, do you still have a basis to lawfully be here? So just because we finish our I-9 verification during the first week of a new hire doesn't mean that our obligations are completely done. IRCA also obligates an employer to basically conduct an I-9 verification. There's this process. In short, it's that we must conduct this for all new hires, U.S. workers, permanent residents, anybody entering in our workforce to be brought onto our payroll, to ask the simple question, are you authorized to work in the United States? And so we have to go through a specific process, time requirements, notice requirements, in order to complete that assessment. Finally, IRCA provides, as do many federal laws, anti-discrimination provisions, meaning that the employer cannot treat different groups of people differently as it applies to this eligibility verification process. Okay, so when do we need to complete the I-9 verification? It's just noted, we previously said all newly hired employees have to go through this verification. Anybody out there who currently is holding a job, I'm sure you yourself have had to undergo this operation. This also includes short-term employees. There's really no time limit on being able to say, well, I'm only going to work for this person for 1 week, therefore this process does not apply to me. It in fact does apply to everyone. There is one additional parameter. IRCA took place and the I-9 process took place and it became effective as of November 6, 1986. So anybody that's currently working in your workforce that was hired prior to November 6, 1986 would not have had to undergo the I-9 process. Anybody hired on or after November 6, 1986 must have gone through this verification process at the time of hire. And later on in the presentation, we'll address what to do if you discover somebody has not yet gone through that process and they needed to do so. So jumping in, we're going to focus on some basic common misconceptions and mistakes regarding the I-9 process and the I-9 form itself. These are questions that we routinely get from employers in all industries, not just relevant to the restaurant industry, although we have seen a spike in questions and inquiries from those in the restaurant and hospitality fields, particularly because this is one of the industries that the current federal government is targeted for heightened enforcement given its history of routine problems. So, if we ask ourselves the question, let's ask ourselves this following question. My company does not hire any illegal aliens or workers who are not authorized to work in the United States. Therefore, we do not need to worry about I-9 issues. If you have this thought, it's a mistake, because in the event of an ICE audit, employers can still be fined, penalized, assessed, evaluated on their I-9 forms generally. I-9, and common misnomer, is that it only applies to those employers who may have unauthorized workers. Not the case. As I just previously explained, the I-9 process applies to any and all hires that you have, and so you should have a form for each one. What ICE also comes in and does is to make sure that you've properly completed the forms, that you have not violated any record-keeping violations, meaning you haven't shredded or otherwise discarded I-9 forms too soon, and even in the absence of having unauthorized employees in the workplace. What if we say to ourselves, well, because there's so much turnover in the restaurant industry, it's really not a big deal if I don't complete a new hire form, because chances are the individual won't be working here 2 months from now anyway. Again, given the high turnover, can we simply ignore our I-9 obligations? Again, big mistake here, because any new employee must undergo the I-9 verification, including short-term employees. Hard for an employer, particularly in a restaurant or hospitality industry. My assumption is that we assume people will work out and stay longer than a day or two. So you should really undergo this process and make sure that you're following it in a diligent, timely manner. Again, we do not get a defense by saying, well, we just assume that this would be a short-term employee. If we have a short-term employee, meaning we anticipate only hiring them or keeping them on the payroll for 3 days or less, then when we get into our timing and obligations, that simply means that we have to complete the whole I-9 process on the first day of hire. Generally speaking, on your screens you should be able to see a copy of the current I-9 form. It is now 2 pages in length. For many of you, you may have been familiar with prior I-9 forms, which were simply 1 page. But this new revised I-9 form was issued in March 8, 2013. I would strongly encourage all of you to make sure you are using the current I-9 form. We routinely get questions and inquiries from clients, or when we help them conduct internal self-audits, we see that the client is still distributing an old or expired form. There is no grace period. USCIS, Immigration Services in this case, has not afforded a grace period for employers to continue to use old forms. So as of today, you should really be using this current form. You'll see the version in the bottom left-hand corner of the sheet. It's Form I-9, version March 8, 2013. So first rule, make sure you've got that form. If you do not have one, you can simply obtain it and go to forms by using the USCIS website, which is www.uscis.gov. And then you can go to their forms drop-down menu and obtain a copy of this form for your workplace. Many of the changes that they made to this 2013 form as compared to prior versions are simply cosmetic. As I said, We went from 1 page to now 2 pages. We now have a more complex set of instructions. The theory behind that was that the government felt additional information would help minimize employer error. So you will see on the instructions themselves, which are now 6 pages in length, that the government has tried to give employers different tips and examples to how to properly complete this form. So in Section 1, just a brief overview here, Section 1 deals with the employee information, which the employee is required to complete. It basically says that Section 1 needs to be completed by the employee no later than the first business day of employment. Simply put, make sure all of your new hires get Section 1 done and completed and returned to you before the end of their first business day. They can certainly do this in advance of starting for you, but if you're going to give an individual the I-9 form, it has to be after you've offered them employment and they've accepted employment. So make sure we're just not doing this step too prematurely. Secondly, you'll notice we've got a Social Security field. The Social Security number itself remains voluntary unless you are an employer that participates in the federal government's E-Verify process, at which point that must be filled out because you'll need that Social Security number to continue the electronic E-Verify system. And then finally, the other piece that the government wanted to highlight here in Section 1 for employees was to make sure, absolutely make sure, that we get the employee's signature in Part 1 of this attestation. To do so, they've added, cleverly or not, and that can be up to you, but they've added some stop signs there to try and make sure that employees stop, check, make sure that they've appropriately signed and dated the form. With respect to Section 2, that's prepared by the employer, and Section 2 begins on page 2. So you'll see now that we have to include the employee last name and first name. This is at the top. We also now have to complete, as we continue to, but Section 2 has to be completed and signed within 3 business days of the employee's first day of work. And specifically, that 3-day calculation is triggered when the employee begins employment to work for pay for us. So make sure that you keep that in mind as well. And then finally, Section 3 deals with re-verification and rehire. This is also found on page 2. A couple things to keep in mind about Section 3. Only List A and List C documents need to be re-verified in the employee's previous grant of employment if that has expired. List B documents, those are your driver's license, your state ID cards, they're omitted from the list of documents that have to be re-verified. If we've checked it the first time around, at the time when we do re-verification, we do not need to go back and recheck a List B document. Finally, you'll see that this is the list of acceptable documents that we can accept as employers for our employees for verification purposes. Some of these documents have been updated. I would strongly encourage, in fact, I tell clients it's required, that you make sure when you hand employees a Form I-9, the best way to do it is to give them the full packet, the full 9 pages, instructions, and all the sheets that they need to complete. But the reason why we do that is we also want to make sure that they see this list of acceptable documents. There are practical reasons to do so, but you want to let the employee know these are the documents that they can provide to you. Any combination of these, either one List A document or a combination of a List B and List C document. But as we'll discuss later, employers should not be directing employees as to what information to give them. You simply defer and refer the employee back to this sheet and say, you can give me whatever you want in any of these combinations, either a List A or a List B and C. One other final piece that I'll just note here is you'll see in the List C document, employers routinely receive Social Security cards as part of the List C documentation for the I-9 process. Finally, we got the government to update this List C document to reflect that we can only accept a Social Security card if it doesn't have any restrictions, meaning it's a plain Social Security card and does not have the disclaimer on there that says only valid with INS or DHS, Department of Homeland Security, authorization. If you get an employee that provides a Social Security card that has this type of disclaimer, you then have to ask the employee, okay, I see your Social Security card, but now you must also give me an employment authorization document because I cannot just accept the Social Security card as it is. It has restrictions. So make sure that you're doing that final step. One good thing that I do think that the government has done with this clarification is made it easier for employers to understand what the limits are with respect to Social Security cards. Okay, so we've got some compliance issues. There are time frames that employers, again, need to be mindful of. And just to recap here, the employee has to complete Section 1 of the form no later than the first day that he or she begins work. The I-9 verification procedure, meaning our employer follow-up requirements in Section 2, where we actually take a look at the employee's documentation and fill out the form, that needs to be done within 3 business days of when the employee starts working for us for pay. If we cannot get this done within 3 days, or if the employee doesn't get us the information within 3 days, best not to let the employee work because they're not authorized to do so. So what some clients do is they say, we're putting you on unpaid leave, or we're taking you off the payroll, not necessarily terminating you, but we're taking you off the payroll until such time as you get this information to us. Some other clients do choose to be a little bit more direct and say, we're ending your employment, you cannot work, we may consider you for rehire if and when you're able to produce this documentation for us. But the gist is, they should not continue to perform services for you or to otherwise receive a paycheck if this process has not been completed. We're also required, again, to make sure that employees complete their I-9 forms after accepting an offer of employment. So we should not be attaching this. We've had some clients do this on occasion where they like to enclose what I will call the I-9 packet as part of the hiring materials. Please refrain from doing so. If you would like to enclose it in materials once an employee has accepted an offer of employment, there's a different distinction there, but make sure that you're not giving it to applicants, as this process only applies to those individuals that you are hiring and bringing into your workforce. Finally, just to reiterate one last time here, short-term employees, this process also extends to them. So if we have an individual that we anticipate will work less than 3 days for us, we must complete this whole I-9 process, steps 1 and 2, at the time the employment begins. We do not get that grace period for the employer to complete step 3. So step 2. So we need to make sure that this is done in a timely fashion. Okay. We've had a client every now and then say, well, during orientation, the employee asked me what documents to produce for the I-9 verification process. And I told her to bring me a copy of the driver's license and Social Security card. Not uncommon for clients to maybe think that because those are the 2 most popular documents that most employers receive, driver's license, Social Security card. However, don't fall into the pit. Don't succumb to the trap here, because an employer cannot direct or instruct an employee as to which forms of evidence to provide for this process. If an employee asks you, the best way to protect yourself, the company, and secure the integrity of the process is to simply refer them back to the acceptable list of documents. It's page 3 of the form that I shared with you. If they have problems understanding, you may want, if there's a language barrier, you may want to have somebody explain this to them. Or if you're giving them examples of what these different documents are, that's fine, but be careful that you are not otherwise directing them to say, give me A, give me B. Again, employees can present one List A document that takes care of both identity and work authorization issues, or they can give you a combination of any acceptable document from List B and an acceptable document from List C. So earlier this week, we hired an individual named Jose to work as a sous chef in our kitchen. Jose provides me with a state ID card and an EAD card, also known as an employment authorization document. Since his name, quote unquote, sounds foreign, I've requested that he provide me with additional documentation from the list of acceptable documents just to err on the side of caution, just to be safe. This is a problem. We have seen this time and time again with some clients. The misnomer is that we're just trying to be extra cautious here. Again, we have to be careful about asking for too much documentation. This is one scenario, contrary to other HR scenarios where high amounts of documentation are good. This is not one of those cases, because if we ask for more documentation than we are legally obligated to get, we could be either potentially committing document abuse, document discrimination, or be running afoul of some of those anti-discrimination provisions that we referred to at the beginning of this presentation under IRCA. So just tread lightly with this particular information. There will be times when you may ask for follow-up documentation, and that doesn't constitute document abuse. What am I referring to? Well, for example, if an employee gives you an expired document, we can say, try again, go back to the drawing board. If we have the Social Security card information, they give you a driver's license and a Social Security card, and that Social Security card has one of those restrictions, not valid without DHS approval, then it's okay at that point to then ask to say, well, show me where your other work authorization is. That's not document abuse. That's perfectly legal. It's perfectly acceptable. If there's another scenario where they give you a Social Security card, but you feel it's fraudulent because you personally looked at it, something's not right, then you can ask them and tell them you're not accepting that document, they need to give you something else. So any of those scenarios, we are not running afoul of document abuse. But again, just be careful of accepting too much, even if you only write down a few of the forms or a few of the pieces of information on the form. If they put a whole spread of information on a table in front of you, then you should ask them, which ones do you want me to accept? You should not just take the whole handful of materials that they give you. Again, too much can be a problem in this case. So you as an HR person, if you say, I'm in charge of HR and I-9 compliance issues for my company, my office is located in Syracuse, New York. However, the new employee that we just hired for one of our restaurants will be working in Buffalo. Since I'm not scheduled to be in Buffalo this month, I'm going to ask the new employee to fax me his I-9 documents so that I can review and verify them. This happens frequently, where we may not be on premises or we're at headquarters and somebody else is in a remote location. So we just have them send it over, either scan it by email or fax it. We review it, fill out the form, and go about our day. That's a problem. Why? Because the whole process and the whole I-9 verification process the purpose is for you as the employer representative to assess and verify this individual's employment eligibility. To do so, you have to look at the real documents, the originals, to make sure that they're genuine on their face, that there is nothing fishy about them, that numbers are not falling off, that we do not have black ink on our hands when we touch cards. And the only way to do that is for you to physically hold and see these documents. Photocopies will not suffice here because it's very easy to hide whether or not the documents are fraudulent. Plus, Section 2 of the Form I-9 requires that you verify that you've done this process correctly. So I also counsel clients to be extremely careful about signing off in Section 2 because you're verifying that you in fact looked at them when in fact you may have only skimmed a copy. So let's recap here. We have to review the original documents from either List A or List B and C. The choice of the document that the employee gives you is up to that employee. Our review of these documents for I-9 purposes has to be done in person. You need to attest that they are genuine in your opinion. Now, you could ultimately be wrong. You might find out years later that they gave you a very good forged document. That's okay. That's not going to get you into trouble. If you reasonably believed at the time when you completed the Form I-9 that the documents they gave you were true correct copies, or true correct documents, excuse me. And then finally, as an employer, you have to be able to conclude that this person is who he or she says he is. Does the photo ID that they're providing look like the person standing in front of me? And then secondly, what about the work authorization document? Is there anything suspect about that, or does everything look to be in order? So now we've got employee Jane Doe. She presents me with a valid driver's license and a Social Security card. So we've got a List B and List C document. Her card has some language on it about needing work authorization, but I don't really pay attention. I simply ask Jane, our new employee, if she in fact has work authorization, and she says yes. I'm relieved that she has the work authorization. I accept the Social Security card and finish the I-9 process. Do we really have any issues here? Well, those should be going off in your head because you see that there was a disclaimer, a limitation on the Social Security card, but did you do anything to check it? So we aren't permitted to accept those Social Security cards in the absence of the document that gives them work authorization. We need those two together. So Jane simply telling you, yes, I have other work authorization, it's in my purse, it's in my wallet, I left it at home, is not going to be sufficient for you to accept for purposes of I-9 verification. Again, you're going to need to ask her, the appropriate follow-up question is, I need to see that card. I need to see that approval notice so that you can then assess and evaluate that. Employee Smith started work yesterday. He brought his expired passport to satisfy the List A requirement, both for identity and work authorization. I made a photocopy of it, completed and signed Section 2, and sent him back to work. Any issues with this? Again, belts should go off here because when we're conducting the initial I-9 verification, we should not accept any expired documents regardless of what they are. So it's key, it's critical that you as employer representatives are checking validity dates, making sure that things are not expired when you do this initial I-9 form. Okay, now Joe was hired in 2014. When he was hired, he presented a work authorization document as part of the I-9 process. So he satisfied the List C requirement. Let's assume he also gave something for List B. So he was valid, properly authorized at the date of hire. The document that he gave to us had an expiration date of February 1, 2015. I forgot to re-verify Joe's work authorization, but I assume he's renewed it since he still comes to work in the kitchen every day. No issues, right? Again, wrong, big mistake. If we have an employee that has a work authorization document which expires, as the employer representative, we have to re-verify the employee's right to work prior to the expiration date of the current work authorization document. So in other words, if this lapsed and it expired on February 1, we should be going to Joe before February 1 to say, we need to see your continued or your new work authorization document. And if we don't get it from you by February 1, we need to remove you from the payroll. He should not be continuing. Now, he very well may be coming to the kitchen every day and still coming to work, but the burden is on us as the employer to make sure that we get him re-verified, and if he doesn't have work authorization to continue, then to basically escort him out of our workplace. He should not be staying on. So an effective way to combat this is make sure we've got a good document management system to send us those reminders about those individuals that we may need to re-verify. You may have a lot in the workplace or you may have very few. But the point is everybody's busy, and the only way you're going to keep on top of this is if you have a good reminder system and a document management system in place. Let's move on to another example here. During the verification process, I make photocopies of the employee's documents and staple them to the Form I-9. By doing this, I don't feel I need to complete Section 2 of the form since all the information is right there for an officer to see. And I'm attaching those photocopies right to the Form I-9. We had a client say this once, and we had to explain to him that this was a mistake because even if you choose to make photocopies, which again, as to be clear, you're not required to do, but if you choose to do this, you still have an obligation to complete Section 2 fully properly and completely in order to comply with the I-9 process. In short, don't cut corners. Don't use abbreviations when you're completing Section 2. Don't skip filling out obvious information because you think you'll get back to it later or that it's just obvious to everybody. Make sure that you are fully and accurately completing all of the different lines, expiration dates, issuing authority, title of the document. You can't avoid doing that process simply because you've retained a photocopy of what the employee has shared with you in support of this process. Okay, now let's assume that Kathy's hired to work as a waitress on Monday. On Thursday, she comes to my office and explains that she's not going to have the documents needed to complete the I-9 process until next Wednesday, more than a week after she started working for us. Because our restaurant is so busy on the weekends, I told her next week is no problem, we're short-staffed, and we really need her to work this weekend. So we then sent her back to work. Again, this is not a safe or prudent approach for employers, because if you have an employee who's unable to provide that documentation to you within 3 business days after starting, this I-9 process should have been completed by no later than Thursday, since Kathy started on Monday. However, if we are unable to do that and complete that process, then as of Thursday, Kathy should be removed from the payroll. She is not working the weekend shift, no matter how busy we are, because she's not authorized to do so. Okay. Let's move on to talking about how best to correct some I-9 forms. There's some general tips here, and we'll go through these fairly quickly because I think many of them are self-explanatory. The first step is to make sure that you actually do, in fact, have an I-9 form on file for each employee. Some clients get nervous, and they say, oh my goodness, we have 100 employees, we're missing 10. Go back, and for those that are missing, let's make sure that they weren't hired before November 6th, 1986, because again, you don't have to have a form for them if they joined your workplace prior to that. So let's ask that initial question. When were they hired? If we're missing the I-9 form and the employee was hired after November 6th, let's correct that error by getting the employee a new I-9 form to complete pronto. The sooner you do that, the better you will be in making sure that you fix this problem. You certainly will not be able to unring the bell that you have not timely completed a Form I-9, but you can potentially mitigate and minimize your risk moving forward if you find the error and through best efforts try to correct it. We are permitted, every now and then, we're all human, errors happen. So we are permitted to correct the Form I-9. Our thought and suggestion and recommendation for clients is that when they make corrections, they should make it using a different colored ink, red, purple, blue if the form was completed in black. But the whole point is to show we've made a correction. What you cannot do is use whiteout or otherwise black out information. Then it looks like you're altering the original form, and that can get you into some problems with ICE in the event that you're audited. It looks as though you're tampering with forms, and it may take away that good faith defense that you have by trying to correct forms in advance of an audit. You also want to make sure when you're looking and checking your forms, conducting a self-audit, that you don't go through and circle things on the original I-9 form. If something's missing, put a tab there. Note it, come back to it. But you don't want to circle it and then give it back to the employee or your employer representative and say, why don't you fix the highlighted things? It's not a good way to go, so you would just want to be careful of that. Any corrections made should be initialed and dated by the person making them. So in other words, if employee information is missing, the employee should be the one to correct that information and then initial and date it on the date in which she makes the correction. The same goes for the employer representative as well. So employee portions of the form, Section 1, should be made by the employee. Employer portions of the form should be made by the appropriate employer representative. If we cannot easily correct an I-9 form, and that happens in a number of cases, maybe it is so poorly completed, then it's best to just have an employee complete a new I-9 form. In doing so, however, do not throw away your old Form I-9. You attach the new one to the old one, and then we suggest preparing a brief explanatory memo, 2-3 sentences tops, as to why the new Form I-9 was needed in this particular instance. At least you're showing we had an I-9 form, we conducted a self-audit, we found some mistakes, and so therefore here's the new form trying to correct those mistakes. But again, it's more important to be forthcoming here to try and establish your good faith defense than it is to say, well, nobody will miss the old form. In terms of tips for maintaining these required records, a couple components here. So first, we are able to maintain them electronically. Many clients are moving in this direction as they are headed into paperless workforces and workplaces. That's fine. You simply want to make sure that if you maintain your I-9 forms electronically, that your system is in compliance with the record-keeping requirements established by federal law. So there's ways in which you have to sign these documents and electronically store them. If you are going to, as I noted earlier, employers are not obligated under IRCA to make photocopies of the documentation, whether it's the passport, driver's license, ID card, Social Security card. We are not obligated to make photocopies. Many employers, however, do so for various reasons, and there's good, compelling reasons why you'd want to do so. For example, you know exactly if there's an issue. If you've transposed a number, you may be able to go back to the document that was shared with you and find your mistake. We've had this come up sometimes when an employee provides one document on day one, and a year later when they re-verify, suddenly it's a picture of somebody else. That's a good red flag for us and a signal that perhaps we need to be asking additional questions. But in short, if you are going to keep copies, you must keep copies of everybody. So you cannot simply say we will keep copies of women's I-9 documents and not men, or we will keep copies of Hispanic documents and not Caucasian. If you have this practice, make sure you're applying it consistently for everyone in your workforce to avoid potential discrimination claims. You also want to make sure you're maintaining your I-9 records for the appropriate length of time. That time frame in that formula is at least 3 years from the date of hire or 1 year from the separation of employment, whichever is longer. In short, you should have an I-9 for all your current employees if you hired them after November 6, 1986. But what's actually helpful here is for some people that get confused by this, there's a good information page on the USCIS website that will walk you through in a formula way so you can write down different dates and do the comparison so that this doesn't confuse you. I also strongly recommend that before you purge any records, because you think it's beyond this retention time, that you have a colleague assess and quote-unquote check your math, if you will, because once you throw out a document, you can't get it back. But at least there can be two of you, so you have some checks and balances in place to make sure that you've done the calculation correctly. And we mentioned it several slides back. Make sure you maintain a tickler system which provides advance notice to you regarding which employees need work authorization and re-verification and when. It's suggested that we tell clients maintain your I-9 records separately from other personnel files. Why? Again, not a requirement, but there's some good reasons to do so. If ICE comes knocking at your door, you're going to want to be able to grab your binder fairly quickly. And you do not have the time nor the luxury to have to pull out this information from each personnel file. If you keep a copy in a binder and you have one binder for active employees and another binder for terminated employees, that's going to go a long way to helping you. And quite frankly, if ICE comes in and says, I want to see these files, you're just giving them the binder that has I-9 information only and not any other DOL information, wage information, potential medical information, which should be kept separately as well. It gives them less to assess and criticize. So that's why we recommend that you keep that separately. And then finally, our last section today is really talking about some practical considerations for ICE audits. Generally, some of you may be thinking, well, why is this a big issue? You may be a mom and pop location, a small establishment. You may be a Fortune 500 establishment. But the hospitality industry, restaurants generally, as I mentioned at the beginning of this program, they are a target of ICE enforcement and have been on this ICE enforcement initiative ever since Obama came into office, President Obama came into office. Here's a few examples. February 2014, about a year ago, an Indian restaurant was fined $77,000 for I-9 violations. In October 2014, an owner of a Chinese food restaurant pled guilty to conspiring to employ and harbor undocumented workers. To bring this close to home, the owner faced up to 10 years in federal prison and a $250,000 fine for harboring those undocumented workers. His managers, operators, and employees were also arrested in the raid. In 2012, Chipotle lost 450 workers following an ICE audit. What was more troubling, I believe, to the client or to Chipotle in that instance was that their legal fees ran more than $1 million. So clearly, ICE is not taking this issue lightly, nor should you, because it's not just the potential fines, but it's the cost that you will incur as an employer in defending your actions. December 2010, an ICE audit found 108 violations against a Subway franchisee. In the initial notice of penalties, they tried to fine this employer $111,000 for those 108 violations. The fine was later reduced by the judge to $200 to $300 per violation for a total of $27,000. Interestingly, in this Subway franchisee case, the franchisee tried to argue that it had no idea that it had I-9 obligations. That argument was quickly thrown out by the judge, who basically found that ignorance of the law is no excuse here. The franchisee also tried to argue that in the past several years leading up to the audit, it had few profits and, in fact, a number of losses, so that it wasn't going to have the financial capability to pay this $111,000 fine. The judge actually did give that argument some credence, although it does not occur all the time, and basically reduced the penalty in proportion to be a little bit more proportional, I think probably in large part so that they could get some money out of this employer. They probably figured some was better than none, but as an employer, we tell our clients, do not rely and hang your hat on just being able to say poor financial performance, because that may not always get you a reduction in penalties. Finally, we want to keep in mind again, December 2012, one last example here, a McDonald's franchise was assessed a $400,000 penalty for knowingly accepting false documents as part of the I-9 process. In short, employers can get significantly penalized for these I-9 violations, even though in your mind you may be thinking, this is a paper, it's a simple document. Sometimes simple can be the hardest to defend. So if you're an employer or you know somebody that's knowingly hiring an individual not authorized to work in the United States, as a first offense, you could be fined anywhere from $375 to $3,200. For the second offense, $3,200 to $6,500 per worker, and then any offenses beyond that, $4,300 to $16,000 per unauthorized worker. You can get tagged for violations, record-keeping violations, which can constitute throwing out forms too soon. And again, these violations assess per record. You can get tagged for document fraud, and those penalties range from $275 up to $5,500. Employers can take steps to make sure that they have a good faith defense here, but those defenses may not absolve you of all liability at the end of the day. Finally, a key piece to realize here is that there's criminal penalties. Employers can get, and their managers in the right cases can get 10 years and up to $250,000 of a fine for harboring, smuggling, concealing, or transporting illegal aliens for financial gain. Certainly, if you're having them work in your workforce, it's hard to refute that you're not obtaining some financial gain from that transaction. So before you get an I-9 audit notice, or before you hear from ICE, or they show up at your doorstep, what's the best thing you can do? You can conduct periodic self-audits internally and correct your errors. Just keep in mind, you're trying to fix the problem, not make it worse. So in other words, Don't throw out the forms that have errors on them. If you need to fix them, go ahead and fix them. Initial, use a different color pen, all those tips that we already mentioned here. But don't throw out the bad and replace it with the good. Make sure you staple them together and go from there. Again, make sure you have processes and procedures in place so that you're accurately reviewing record retention issues. Talk to a colleague and say, I think this group of forms has now expired. We don't need to keep them. Please check my math, and wait to do that before you take any action to otherwise shred or discard those forms. And then finally, make sure you're training those individuals who have I-9 responsibilities. Time and time again, employers are relying and authorizing individuals who have absolutely no knowledge of this process. And yet their lack of knowledge can result in fines and penalties to the company. If you have a point person doing I-9, make sure they get proper training. If there's errors to fix and you see repeat errors, make sure, if you haven't trained them initially, you get the person the training that they need so that they don't continue to make those mistakes. And then finally, if ICE is knocking at your door, I think the last piece that we just want to make sure that we look at is that we want to make sure I'm sorry, we're having a little technical difficulty here. If ICE knocks at your door, you're going to want to ask for a written notice of inspection. Why? Because you want the exact time frame that they're looking for, and you want to be clear as to what they're looking for. Do not assume. Get a written notice of inspection so that you know exactly what you need to respond to. Secondly, if ICE comes knocking at your door, ask the officer for identification and a business card. Is this person who he says he is? Is he truly a government official? We've got a number of people out there every now and then that can be imposters. So before you give somebody some safety sensitive or personally sensitive information, which there is quite a bit of on these Form I-9s, make sure you're actually in fact speaking to a government officer. The officer should not be offended if you ask that person for a business card or for identification or to show you a badge. Third, as the employer, you by right have 3 business days to turn over your original I-9 forms. Just because they're at your door today on Wednesday at 2:30 p.m. doesn't mean that you need to let them in at this moment. You can take your time and say, thank you, I'm going to take my 3 business days and we'll reach out to you at that time. But take the time so that you can gather yourself, your thoughts, your documentation, and figure out how you're best going to present this information. Unless the only caveat to that is if they have a warrant and they do not need to extend you those 3 days. So just keep that in mind. And then finally, make sure you're cooperating fully with ICE. We're not here to be confrontational. You want to work with them, as this officer is the one that's going to be assessing your workplace. But just be careful. Provide the information that's been requested. Show or give the officer the necessary hardware and software if you keep your documents stored electronically. A final point that I would just note here, quite frankly, is that you want to keep them to a quiet part of your facility. The ICE officer may try and talk to your employees, may try and ask for a tour of the facility. That is not a requirement. And so the more restricted you keep their access to your building, the better it will be for you. I've also just attached here just a general picture of the ICE investigative process, which usually starts with that notice of inspection. They look at the forms. If they find violations, they'll determine whether those violations are substantive or technical, and then they will determine what amount of fines, if any, will be assessed against your company. In terms of questions, so we're available to take a few questions. We have a couple more minutes here. And actually, I think we do have a couple questions. So the first one that I received is, do I have a right to re-verify every document that has an expiration date? It's a great question. We get this all the time. The short answer is re-verification is not necessary for those identity documents. For example, if your driver's license expires, you should not run to your employees and say, get us a new copy of your driver's license or state ID card. If a U.S. passport expires, as long as it was valid at the time you conducted the I-9, the fact that it may expire while the individual is still an employee with you does not mean you necessarily or should go back and re-verify that U.S. worker. The same goes for permanent resident cards, but permanent resident cards are the questions that we get most often. A permanent resident card will have an expiration date on it. That does not mean, however, that once the card expires, the person is no longer a lawful green card holder or permanent resident here. So you should not be re-verifying your permanent resident simply because the card is expired. You are re-verifying those documents in H-1B, an L, a work authorization card that has expired. That's fine, but just remember not to do it with respect to those permanent residents, U.S. citizens, or for ID cards, simply because that could be determined to be document abuse and potentially discrimination charges, depending on who you keep going back to and asking for that information. Okay, we've also got another question here about an internal audit. So during an internal audit, I discovered that my HR predecessor routinely forgot to have employees sign the attestation in Section 1. Assuming that individuals are still employed with my company, can I ask them now to sign and date Section 1? Short answer is yes, you can. If you discover this during your internal audit, you can try and correct this with the following caveat. You have to have the employee sign the signature box and date it on the date that they're actually signing. They cannot backdate. So if you hired them in 2005 and you catch this error on February 11th, 2015, they should not be signing their name and dating it 2005. They should be using today's date. So what you will also want to do is have them initial and date the margin, because that's showing you corrected the error on this date. You may also want to put a little note with it that says error was discovered during self-audit conducted on whatever date you discovered it, so that it triggers that you have not tried to fix or improperly fix the forms or slide information in an inappropriate manner. Okay, we've got two more. So the third question is, how do we correct the Form I-9 when the employee has signed his or her name? So they've actually signed it, but they failed to print their name. That's a two-step process. Can we, the HR person or the I-9 representative responsible here, just print the box in without having to go back to the employee? Our recommendation and advice is to go back to the employee to fix Section 1 issues. That's their portion of the form that they need to complete. Even though you may be able to legibly print their name, that's not them doing it. So again, first course of action would be have that individual just print their name. Again, initial and date in the margin to show when they made that correction or addition. If they're no longer in your workforce to do so or no longer with you, then I would just leave it and put a self-explanatory note or a brief memo that just says you couldn't have the employee correct this because they're no longer employed in your organization. And the last question that I've got is, my boss is frequently out of the office, but she's responsible for signing the Form I-9 for our company. In an effort to comply with the 3-day rule, I sometimes sign the form on her behalf and initial her signature. So it's clear that I'm not pretending to be her, but I'm signing on her behalf when she's out of the office. Is this okay? The answer is no. Don't do this, because the employer attestation is very clear in Section 2 that the individual who has reviewed the document is the one who has signed the document, so they should be the one signing this form. You should not be signing on anybody else's behalf. If you're the one to review the document, then you go ahead and review it, and you may have to do that if the point person is out of the office for vacation or is sick or is traveling that day. But better you review the document and the form and let her make corrections when she comes back than to misrepresent by signing her name, even though you've initialed that you've signed on her behalf. Those are all the questions that we have at this time. And so I want to thank everybody for participating. And again, just strongly encourage you, if you do not conduct self-audits, we strongly recommend that you do so to get a general sense of whether or not your records are in good shape, because it's not a question of if, it's a question of when ICE or some other federal government officer shows up in terms of some of these enforcement initiatives. So thank you for your time today. Appreciate you participating.